A recent USCIS policy memo triggered widespread fear among immigrants across the United States. Families, workers, students, and spouses of U.S. citizens began questioning whether adjustment of status was still safe. Many worried they could suddenly be forced to leave the country, even after filing Form 1485. The original memo emphasized that adjustment of status is discretionary, meaning USCIS officers are not required to approve a green card application simply because an applicant appears eligible. Instead, officers are instructed to evaluate the entire case and decide whether the applicant deserves a favorable exercise of discretion. This immediately raised concerns that many immigrants could be pushed into consular processing, requiring them to leave the United States and complete their green card applications abroad. For countless individuals, departing the country could trigger severe immigration consequences, including 3-year or 10-year unlawful presence bars, family separation, employment loss, or long delays caused by embassy backlogs. However, DHS has now clarified that the memo was not intended to eliminate adjustment of status for most applicants. According to the latest guidance, the majority of green card applicants may still remain inside the United States while their applications are processed. Yet the clarification does not eliminate the risks. USCIS officers still retain broad discretionary authority, and interviews may now involve more detailed scrutiny than before. This means applicants should remain hopeful, but also significantly more prepared. Although DHS softened the original message, immigration attorneys report that USCIS officers have already begun asking more detailed and difficult questions during adjustment of status interviews. One of the most important questions now being raised is, why are you applying for adjustment of status inside the United States instead of completing consular processing abroad? This question is designed to evaluate whether the applicant has a legitimate reason to remain in the United States during the green card process. A weak response focused only on convenience may damage credibility. Stronger answers often involve family hardship, medical responsibilities, employment obligations, financial dependence, or legal risks associated with leaving the country. Another common question is, what prevents you from applying through consular processing? For many applicants, the answer may involve unlawful presence bars, separation from U.S. citizen family members, medical treatment, or serious hardship to children and spouses. USCIS officers may request supporting evidence to verify these claims, making documentation more important than ever. Applicants with visa overstays or prior immigration violations may also face direct questions about why they remained in the United States after their authorized stay expired. USCIS officers are increasingly focused on honesty, consistency, and credibility. This new environment means applicants must approach interviews carefully. Immigration officers are trained to detect inconsistencies, exaggerations, or fabricated explanations. A single dishonest statement can create far greater problems than the original immigration issue itself. Not every applicant faces the same level of risk under the updated DHS clarification. Certain categories of immigrants may still receive closer examination from USCIS officers. Applicants with visa overstays, unauthorized employment, immigration gaps, prior status violations, or inconsistent immigration histories may experience more difficult interviews and greater scrutiny. While these factors do not automatically lead to denial, they can heavily influence how officers exercise discretion. Employment-based applicants may receive somewhat more favorable consideration if they can demonstrate that their work benefits the U.S. economy or national interest. This includes highly skilled professionals, researchers, healthcare workers, investors, and individuals applying under national interest waiver categories. Family-based applicants also remain eligible for adjustment of status, particularly those sponsored by U.S. citizen spouses, parents, or children. However, officers may now expect stronger evidence showing that the applicant's life is genuinely established inside the United States. Marriage-based applicants should prepare extensive documentation proving the legitimacy of the relationship. This may include joint financial records, lease agreements, photographs, communication history, tax filings, insurance policies, and evidence of shared family responsibilities. Meanwhile, individuals who entered the United States without inspection continue to face separate legal limitations. Many of these applicants still require waivers or consular processing and may not qualify for adjustment of status unless they fall under a specific exception. Ultimately, eligibility alone is no longer enough. Applicants must now demonstrate why their case deserves approval as a matter of discretion. For immigrants with pending I-485 applications, the most important response right now is preparation, not panic. USCIS still has authority to review discretionary factors during interviews and case adjudication. This means applicants should carefully review every aspect of their immigration history before attending an interview. Applicants should organize entry records and visa history, marriage evidence or employment documentation, tax records and address history, evidence of lawful behavior and community involvement, documentation explaining any overstays or immigration complications. Strong cases are not always perfect cases. In many situations, USCIS officers understand that immigrants may have experienced financial hardship, family emergencies, confusion about immigration rules, or other difficult personal circumstances. What matters most is honesty, preparation, and consistency. Applicants should never conceal prior immigration issues or assume officers will overlook them. If unauthorized employment occurred, it should be addressed honestly. If there was an overstay, applicants should be prepared to explain the circumstances clearly and provide supporting evidence whenever possible. Missing an interview, submitting incomplete documents, or providing inconsistent answers can seriously damage an otherwise strong application. That is why legal guidance has become more important than ever in this evolving immigration environment. The DHS clarification has provided relief for many immigrants by confirming that most green card applicants will not automatically be forced to leave the United States. However, the policy memo still carries significant consequences. USCIS officers may now evaluate adjustment of status cases more carefully, ask tougher questions, and apply discretionary standards more aggressively than before. This means applicants should not rely on rumors, social media speculation, or incomplete information. Immigration policy can shift rapidly, and the true impact of these changes often becomes visible only through real interviews, requests for evidence, notices of intent to deny, and final case decisions. The most important strategy right now is balance. Remain hopeful, but stay fully prepared. Applicants should understand their immigration history, organize strong evidence, prepare truthful explanations, and treat every interview seriously. Adjustment of status has not been eliminated, but the quality and credibility of each case now carry greater weight. One final warning is especially critical. Applicants should never travel outside the United States without first understanding the immigration consequences. Departing the country could trigger unlawful presence bars, abandonment issues, or long delays abroad. Before making any travel decisions, immigrants should consult a qualified immigration attorney who understands their complete immigration history. In the end, this new DHS guidance does not signal the end of adjustment of status. Instead, it marks the beginning of a more demanding immigration environment where preparation, documentation, honesty, and legal strategy matter more than ever before.